back to the International Business and Law Academy. My name is Anne, and today we will be continuing the series on Nafta. And specifically today, we're going to talk about the trade barriers of Nafta, the North American Free Trade Agreement. We'll discuss more about the trade barriers of the countries and discuss about the trade institutions in the free trade agreements of Canada, United States, and Mexico. The first principle is of safety measures and technical standards. NAFTA recognizes each country's right to adopt and enforce technical standards, to choose the level of protection it wishes to achieve, and to conduct risk assessments to ensure those levels are met. The second principle is of intellectual property rights. NAFTA sets out specific commitments regarding the protection of patents, copyrights, trademarks, trade secrets, industrial designs, integrated circuits or IC, or semiconductor chips. The third principle, competition policy. The NAFTA partners agreed to provide effective enforcement of antitrust laws. Through cooperative enforcement efforts against anti-competitive governments and private business practices, they hope to eliminate unnecessary interference of cross-border trade. Government procurement. The government procurement market for goods and services has been substantially open to all suppliers within the free trade area on a non-discriminatory basis to suppliers from any NAFTA country. The treaty does not apply to procurement of weapons and other purchases that directly involves national securities of other countries within NAFTA. Temporary entry. Each of the countries may still implement its own immigration policies, safeguards, and to protect its domestic workforce and protect its borders. Despite these national reservations, treaty members have agreed to facilitate the temporary entry of business people from other NAFTA countries. Anti-dumping and countervailing duty disputes. Dumping occurs when an exporter sells goods in one country for less than the price charged in another in their home country. If dumping causes material injury to importing country of the domestic industry, the importing nation may assess anti-dumping duty to offset the advantage position of the exporter. Well, I just talked about all the principles of the NAFTA trade barriers, where I talked about the removal agreements and principles. Now let's talk about it. Ruby, can you please start us off by talking about the safety measures?
So for safety measures and technical standards, I know that NAFTA recognizes each country's right. However, it requires the partners to ensure that the standard provide both national treatment and most favored nation treatment.
That's correct. Soren?
Yes, I agree with Ruby. Intellectual property rights ensure that each country will provide effective protection of such intellectual property rights on the basis of the national treatment.
Right. So all of that brought up competition policies, right? Recognizing that each nation may grant monopolies in limited circumstances, the treaty mandates that such entities not discriminate against the goods or businesses of the NAFTA countries.
I also think that the government's procurement obligations require each country to publicize any technical specifications, qualifications of suppliers, and time limits of submitting bids.
That's correct. Ruby, please continue talking about the temporary entry.
So there are 4 categories of business people who will be granted the temporary entry, which are business visitors, traders and investors, intra-company transferees, and certain categories of professionals.
About anti-dumping and countervailing duty disputes. Likewise, if it was imported at a price lower than the domestic good because they are subsidized by the exporting country, may access a countervailing duty equal to the amount of the subsidy.
That's true, Soren. Well, thank you all so much for talking with me about the trade barriers of the 3 North American countries, and also clarified the goodwill to remove barriers of the 3 countries. Well, in order to apply what we just learned, let's talk about the case study, West Coast salmon and herring from Canada. The facts are, in 1986, Canada enacted regulations prohibiting the export of unprocessed salmon and herring. Responding to the complaints of the United States, a G8TT panel in 1987 found that Canadian laws violated the GATT. After informing the United States that it would accept the GATT decision, Canada revoked offending the legislation. However, several months later, the Canadian government passed new laws that required that salmon and herring be landed in Canada before they could be exported to the United States for processing. The United States called for the formation of a binational panel, arguing that the new regulations were a trade barrier that discriminated against US processors. Canada defended on the grounds that its landing requirements fell within an exception for measures relating to the conservation of an inexhaustible natural resource. So the issue here is, should the binational panel find the landing requirement to be a trade barrier that violates the free trade agreement? Torin, can you please talk about this?
The fact that the export restriction had been imposed in the past provides some evidence that this regulation would impede a meaningful volume of exports.
John, what are your thoughts?
So I think it is unlikely that Canada would have found the compensation's benefits of 100% landing requirements to have overcome the commercial inconvenience if it had been imposed on Canadian buyer rather than on export buyers.
I agree. Ms. Wan?
I think that's that Canada and Arctic regulation prohibiting the exports of unprocessed salmon and herrings is seen as they are trade barrier.
Ruby, can you please clarify what the United States were arguing about?
So the United States called for the formation of a binational panel, arguing that the new regulations made were a trade barrier that discriminated against the US processors. And I think yes, because the landing requirement to be a trade barrier violates the free trade agreement.
Well, thank you all so much for that wonderful discussion. So let's talk about the case again. Should the binational panel find the landing agreement for as a trade barrier that violates the free trade agreement? Well, the decision is yes. Canadian landing requirements is a restriction on sale or export within the meaning of GATT, and hence, prima facie, is incompatible with the free trade agreement. There is no doubt that catch information is vital to the Canada's management of its salmon and herring fisheries, and that landing agreements can play an important role in obtaining that information. Well, thank you all so much for your discussion again. If you have any questions, please ask me now. Well, that's wonderful. Thank you so much to the International Business and Law Academy, and especially Dr. Sung.